What's up, everybody? We're back at it here today on The Lawyer You Know, talking Amber Heard, Johnny Depp. It's appeal time. We've already hit so much of the appellate process. We've talked Johnny's brief. We talked Amber Heard's main points of contention. We talked the amicus brief. But today we get to the actual appeal for Amber Heard. What are her main arguments? What case law do they have? And I feel like a lot of people have already broken this down. You've probably read through this with a lot of people already. I'm going to try to make this not repetitive and not go over a lot of the things we've already spoken about in what the summary of her arguments were going to be, in some of the facts of the case that we all watched together, and talking about whatever was in the amicus brief. But what we're going to do a little bit different today, to give you a different angle and a little bit of a different vibe, while it may be some of the same discussion and arguments, we're going to talk about what the brief looks like and how it's set up. And then I am going to go through the arguments and put them into categories. Okay, so there are certain arguments that are decent arguments on Amber Heard's side and have at least a non-zero chance of being successful. Then number two, there are arguments that, depending on how Virginia case law actually is, we just don't know, and a judge is going to have to make a decision. But in that situation, I would feel like I would know how the case law is in a lot of federal courts or in the state courts in Florida. But because it's in Virginia, we're not positive as to how it should come down. However, I will just tell you, there are times where I think it's positive and the court rules against me, obviously. That's why two lawyers object and make arguments and the judge makes the call. Then the appellate court usually agrees with that judge. So we'll keep that in mind as we review some of this, that a lot of these arguments, Johnny Depp's lawyers disagree with them. They know Virginia law. And the judge disagreed with them, who also knows Virginia law, which is why appeals are always an uphill battle. And then category number three is going to be arguments that maybe they do make sense. However, they already made these arguments to the jury and the jury decided against them, which makes it very, very, very unlikely she's going to win on those arguments. And category number four, no shot, not going to happen. Case isn't going to get appealed because of this argument. So we'll kind of talk about which one of those four buckets some of these arguments go in. We're going to hit a lot of the brief. We're not going to read every word of it, and I'm going to do my absolute best to do this in an hour. Feels like an impossible feat, but we are going to answer questions at the end as well, and probably take some breaks as we read through this brief to shake it back up and answer some questions. So thanks for being here. Most of you are probably subscribers, but if you're not, hit that subscribe button, because like a third of the people that watch every video are still not subscribers. That number's going down, but I'd like everybody to be subscribed because it's more fun when people are subs to the channel. And get in the chat, get your questions in. I will answer as many of them as I possibly can at the end. And hit that like button if you haven't already. If you still enjoy this content, which I know some people don't, and that's okay. It's probably not my favorite content that we do, but it is still interesting. What's really cool, the coolest part about this Depp v. Heard case is we're seeing a full process, right? We're seeing the trial go through, and we're seeing the full appellate process, and people are really starting to understand the full scope and how long it takes and how laborious it is and how wordy it is. And they're really understanding that process fully. So hit that like button if you still enjoy this Depp v. Heard content. Let's get into it together, right? We know it's Amber Heard's appeal. There's a table of contents that sets out what we're arguing, where everything is. And then we're going to get into all this, right, as we go through it. So this is not something we have to hit 3 times. We have a table of authorities, which is all the case law that they are relying on. And what's interesting is as you scroll through this, you'll see there's some Supreme Court decisions, some New Mexico court decisions, Virginia court decisions, New Jersey court decisions, Delaware, New York, Michigan, Minnesota. So as we talked about before, there are certain courts that are precedent and you have to listen to them. And here are the statutes and other authorities and rules that they used. Okay. So there are certain courts that you have to do what they did. You can't overturn what they did without some major change happening in the law. But then there's a lot of other courts that can be persuasive. And that's when you see just another state court. They're saying, this is how that state applies it. This is how we think you should apply it in Virginia as well. So the statement of the case. At this point, if you don't know what's going on in this case, you're probably going to be lost at some point during this video. So I'm not going to take a ton of time going through the fact that Amber Heard accused Johnny Depp of domestic violence in a number of different ways. Johnny Depp sued her for defamation when she put it in a Washington Post op-ed and put it out to the world on Twitter. It went to trial. Johnny Depp won to the tune of $10+ million. But Amber Heard also won in her counterclaim on one of the statements that Adam Waldman made about Johnny Depp. Okay. The assignment of errors. We went in depth into these 16 when it was just these paragraphs, what we thought they were going to argue, what we thought of those arguments. But today in this appellate brief is when we can dive deeper into these arguments. Statement of the facts. Again, we're just going to hit the headings here because we want to get to the actual legal arguments and put them in one of the 4 categories I mentioned off the top. The 2016 domestic violence proceeding. We know about that. Depp's lawsuit against The Sun. The Sun was a trial in the UK where a British newspaper published an article calling Depp a wife beater. He sued them. He lost. The court basically believed Amber Heard. Multiple actions of domestic violence. They found Amber Heard to be at least somewhat credible, and they ruled against Johnny Depp, but Amber Heard was not a party. This was not a dispute between Johnny Depp and Amber Heard. This was a dispute between The Sun and Johnny Depp, and The Sun won, which will become important later. Then Amber Heard writes the op-ed and basically tells everybody that she was a victim of domestic violence 2 years ago. So by implication, everybody knows she was married to Johnny Depp. She filed the restraining order that ended up going away once they settled for $7 million in the family law case. And then Johnny Depp sues her because he is damaged by that op-ed where he starts losing parts. He starts losing money. His reputation gets hurt because of Amber Heard and the domestic violence that apparently happened at the hands of Johnny Depp, or allegedly, I should say. Then there were a lot of pretrial proceedings where they filed a lot of these motions that we're going to talk about today. We had the trial. It was put before the jury, and the jury decided for Johnny Depp to the tune of $15 million, which was reduced to $10.35 million. And they awarded Amber Heard $2 million with no punitive damages against Johnny Depp. So they wanted to punish Amber Heard. They did not want to punish Johnny Depp, which is all important when we talk about some of these factors in the appeal. Also, big numbers, but not even as big as the lawyers were asking for, which will be important as we discuss one of the arguments here. All right. Johnny Depp's case should have been dismissed prior to trial. This is argument number 1, and let's hit the reasons why they feel that way. The first one is forum non-conveniens. This case should have never been tried in Virginia. The record overwhelmingly demonstrated that Virginia had no meaningful, let me put this here in case John texts me. Okay. No meaningful connection to Depp's claims, and that California was the only appropriate venue. The trial court therefore erred in denying Heard's motion to dismiss for forum non-conveniens. And Depp's claims should now be dismissed without prejudice for this reason. So they want him to go file it in California, where they probably should. Where they should have in the first place, or it's the best jurisdiction and venue for this case. But just because it may be the best based on somebody's argument does not mean it's the only, and does not mean it's improper or illegal or unlawful to have the case in Virginia. And that's where I think they lose this argument. Virginia's forum non-convenience statute permits a trial court, for good cause shown, to dismiss an action brought by a person who is not a resident of the Commonwealth without prejudice if the cause of action arose outside the Commonwealth, and if the court determines that a more convenient forum, which has jurisdiction over all parties, is available in a jurisdiction other than the Commonwealth. The trial court's decision is reviewed for abuse of discretion. Abuse of discretion is a very high standard of review. The judge had to abuse their power and discretion by making this decision, because we all have to agree at this point, the judge in this case made the decision that Virginia was a proper venue. A court abuses its discretion when it makes an error of law. Here, the trial court made an error of law in concluding that Depp's claims arose from Virginia rather than outside the Commonwealth. Had the trial court correctly applied the law in this regard, it then would have been required to consider whether a more convenient forum with jurisdiction over both parties was available. The evidence before the trial court demonstrated California was such a jurisdiction. But because of the erroneous legal conclusion, the trial court never considered the substantial inconvenience and prejudice to litigating in Virginia would impose on Heard. So just because it's inconvenient to have the case there is absolutely not what forum non-convenience means. And in my opinion, the servers and it being kind of published and sent out from Virginia is actually a pretty good nexus to have a case like this when you're saying that is what caused the problem. Now, obviously, California would have been an appropriate jurisdiction and venue as well. And there is something, some states don't like forum shopping, meaning picking the best place for you, but it's not like he went to Idaho and tried this case. He picked a place that was legitimate and it was a legal decision by his legal team, in my opinion, is appropriate. But I do think this needs to be thrown in the bucket of, well, if Virginia's going to look at case law this way, maybe they would decide that this is not the right forum. However, when you look at the fact that the judge already at the trial court level disagreed, they disagreed again with the post-trial motions. The lawyers on the other side of the case obviously disagree because they brought the case here. I think this is an uphill battle, and I don't think it's one that's going to be successful. It arose outside of Virginia. The computer servers are located in Virginia, but Virginia adheres to the rule of lex loci delecti, which is the place of the wrong to determine where a tort cause of action arises. For defamation claims, Virginia courts have defined the place of the wrong as the state where the content at issue was published. Neither the Virginia Supreme Court nor this court, however, has addressed how the rule applies to defamation claims based on internet publications, which reach an audience in multiple states simultaneously. That is difficult, and that is something that needs to be decided, right? That is something that is very important in this case. And to me, it's an unsettled area of law, which means it's going to be really hard to prove that this is an abuse of discretion or an error in law when they don't have case law on point showing that this was, in fact, wrong. The trial court incorrectly concluded that the publication for purposes of online multi-jurisdictional cases occurs when the defamatory statement is uploaded to the internet. To the contrary, under Virginia law, a statement is not considered to be published until it is seen or heard by a third party. Uploading content to the internet is not enough to constitute the completed tort of defamation. Instead, a third party must also receive it. This is them, in my opinion, piecing different parts of a rule and case law together to make it say what they want it to say, because to me, where it was sent out and populated from is a very good nexus for a case like defamation. Numerous courts interpreting Virginia law have concluded the place of the wrong for internet defamation is where the plaintiff incurs the greatest reputational injury. Well, when you're a worldwide superstar, I think that is also difficult to pinpoint. Typically, though, it's their home state. And when you're a movie star, California also makes sense for that as well. Here, the state of California was Depp's home. There's no doubt about it to me that California was the better forum, the most appropriate forum. But that does not mean it is the only place that was appropriate for this case to get filed. Virginia was a completely inconvenient forum because the trial court erroneously concluded that Depp's claims arose out of Virginia and Heard, therefore, had not met the prerequisite to dismiss the case based on forum nonconvenience. It did not consider whether there was good cause to dismiss this action. Good cause includes, but is not limited to, the avoidance of substantial inconvenience to the parties or the witnesses. To me, people like them, when I say them, I mean celebrities, it's not that inconvenient to have a case in Virginia. It's not like they had it in Russia, in the Siberian, whatever. Had the court analyzed good cause, it necessarily would have concluded that Virginia was a completely inconvenient forum for this case. Less convenient, but we've heard Amber Heard make arguments that she wasn't domiciled anywhere. She was stateless at the time, right? None of the conduct relevant to Depp's defamation claims occurred in Virginia. Depp is a resident of California. Incidents that led to the restraining order took place in California. Heard wrote the op-ed in California and sent it to the ACLU in New York. Sorry, they're saying it could have been New York. ACLU provided the op-ed to the Washington Post. Here's my question. Why did it have to be the Washington Post? Why couldn't they have picked a California newspaper or somebody in New York if they really wanted that to be the place, right? Amber Heard theoretically chose the Washington Post, or they chose each other. Heard had no contact with any Washington Post employee. To the best of her knowledge, Heard had never set foot in Virginia prior to the lawsuit. In short, the Washington Post computer server's presence in Springfield is the only connection between these claims and Virginia, which means Depp's choice of forum is entitled to little weight. I disagree, right? Just because you've never stepped foot somewhere doesn't mean something can't happen there, especially if you're doing things like If I send a package somewhere and it blows up in that state, they can sue me in that state, even though I've never stepped foot in that state, right? She basically sent this package that exploded on Johnny Depp in another state and all around the world. In contrast, both parties and most of the fact witnesses were located in California, with none of them located in Virginia. I agree. California was the best place for this case. Absolutely. And they didn't choose it because of the anti-SLAPP statutes that make it way more difficult in California. And I don't think Johnny Depp wins this case in California, but he had a resounding win in Virginia. That does not mean that she should win because of this only, right? Just because California was a better forum does not mean it was the only forum. Because of this error, Heard suffered substantial prejudice in two ways. First, and most significantly, Heard was unable to subpoena any witnesses for the 6-week trial and was forced to rely almost exclusively on deposition designations to defend herself. So it being inconvenient, it was no more inconvenient for Amber Heard than it was for Johnny Depp. So it's not like this was unfair, like she had to do certain things that he didn't have to do, or she lived in state X and he lived in state Y, right? They were coming from equal footing, which I think probably had something to do with the judge's determination in the first place. Presentation of deposition testimony at trial as a less desirable procedure. We all know that it's less desirable to present by video deposition. The lack of a compulsory process meant, and we talked about this, they couldn't force the witnesses to show up in person. So because of that, if a witness didn't want to show up, they had to be played by deposition, which was clunky. It was weird. The process was backwards. The other lawyer went first, wasn't able to ask cross-examination questions, was definitely less effective, but both sides had to deal with that. And the fact that no witnesses wanted to voluntarily show up for Amber Heard, it says what it says, right? Depp, who has, and again, that's not a reason why you can choose one court over the other. Like Amber Heard can't necessarily say, I just want this case to be in this state because you can't force people to show up as a witness, or I want to pick at this state because you can force them to show up as a witness. You have to actually have a nexus, which in this case they did have in Virginia, at the very least, right? I'm not saying that this is not her worst point, right? This is not her worst argument in this appellate brief. Depp, who has considerable resources from his decades as a movie star, was able to call more than 15 live fact witnesses who voluntarily traveled to Virginia from another jurisdiction or appeared by WebEx, many of whom are employed by or otherwise financially linked to Depp. So what stopped Amber Heard from using WebEx? Because it doesn't take any resources at all to use WebEx. Depp capitalized on the disparity, arguing to the jury. This is like saying, it's not fair, judge. This side had more witnesses. This side had more people that were willing to come and testify for them. This is not a good part of the argument for Amber Heard. Like, it was unfair because we had to play video depots because nobody would show up for us is not a way she's going to win this argument. Now, saying that California is better because they both lived there, there was a nexus there, that was the more appropriate forum for it, and she wrote it there, that's a better argument. This one's not a great argument. Other than she was able to have her experts show up, right? Because she legitimately paid them to show up. So they were all able to show up. She had the resources. So it wasn't the resources that was the problem. Other than a witness who traveled to Virginia for her as a paid expert, this is a woman who burns bridges. Her close friends don't show up for her, is what Johnny Depp said. And they did make that argument, and they're allowed to make that argument. That argument does not prove forum nonconvenience, and it is true. An expert did show up for her. So if resources were the problem, why was she able to pay an expert to show up for her? Second, the lack of compulsory process prevented Heard from responding as Depp shifted his case. And remember Alejandro on his phone. So the court was letting that type of stuff go as a witness, right? As a deposition playing. Like, it wasn't the most professional thing I've ever seen, but the lack of compulsory process prevented Heard from responding as Depp shifted his case. While Depp was able to redirect witnesses and call new, previously undisclosed witnesses in rebuttal, Heard was reliant on video deposition testimony. This is precisely the kind of disadvantage the doctrine of forum nonconvenience was designed to prevent. I disagree. The trial court abused its discretion in denying Heard's motion to dismiss, and this court should now reverse. Okay? The trial court should have dismissed Depp's claim because the challenged statements are non-actionable expressions of opinion. And I saw a comment on this already. Christy was watching Popcorn Planet, and apparently Amber Heard wants the verdict overturned because it doesn't matter if she lied because she believes he abused her, thus overturned. She's nuttier than evil fruitcake. I will say, from the jump of the trial and still to this day, if Amber Heard would have stuck to only what Johnny Depp admitted and said she believed that that was abuse based on his text messages and his words, then that could have been a constitutionally protected opinion. I think she went way too far. The lawyers lost the argument throughout the trial, bringing in the SA and bringing in some of the specifics and the huge injuries and the broken noses and the cuts and scrapes and bruises. And the jury just felt like she was lying about everything at that point. But the squeezing of the arms, the accidental headbutt that she could have said she thought was on purpose, she didn't know it was on accident, coupled with some of the words and text messages, I think that's a much more plausible explanation that in her opinion, she was a victim. But when she said it as fact and added a mountain of evidence that didn't exist, that's where I think she lost it. And again, that's basically what this argument is. Whatever statement is an expression of opinion is a question of law. The three challenged statements, I spoke up against sexual violence, which is obviously true, are protected. There's no objective evidence with truth or falsity that she felt or faced our culture's wrath, whether she is a public figure representing domestic abuse or whether she saw institutions protect men. These statements are relative in nature and reflect her subjective viewpoints. The trial court violated its essential gatekeeping function by allowing the jury to consider these non-actionable items. And again, those statements technically are true, right? She faced the culture's wrath. I should say are her opinions. And you can't prove that she didn't face the culture's wrath. You can't say that she didn't speak up against sexual violence. The point is the jury did not believe that any of the underlying things, and they basically called her a fraud for writing the piece because they don't believe any of that actually happened to her. All right, next. Should have been dismissed because the statements are not reasonably capable of conveying a defamatory implication as a matter of law. This is one of those I just completely disagree with. So you're trying to tell me that she did not think that this article would at all imply something that would hurt Johnny Depp. Think about that. The alleged implication must be reasonably drawn from the words actually used. A plaintiff may plead innuendo to show how the words used are defamatory and how they relate to the plaintiff, but innuendo cannot introduce new matter nor extend the meaning of the words used or make that certain which is in fact uncertain. It is not the province of an innuendo to enlarge the meaning of the alleged slanderous words. Its use is to explain the matters already expressly alleged. Whether a statement is reasonably capable of a defamatory meaning ascribed to it by innuendo is a question of law. The reason they're saying question of law, meaning the judge and the appellate court should make this decision. It should not be left to the jury because, as we know, the jury disagreed with Amber Heard every chance they got. It is undisputed that the op-ed does not mention Depp's name or the party's relationship. I'm not even going to read this any further because it was so obviously about Johnny Depp. We have emails from the ACLU where they referenced Johnny Depp. There were versions of this that said his name that they removed. They knew it was about Johnny Depp. That's the only reason anybody wanted to read it. And it went out to lots of people. It was negative about Johnny Depp. It referenced the timing of their relationship, which obviously hurt his career. And they brought up a bunch of news articles that said the same. So we don't really need to go into this. But she's saying basically because she didn't say his name specifically or specifically reference their marriage or their relationship and recount the acts of domestic violence that she did testify to at trial, it didn't specifically say the bottle incident or the cuts on the feet or the headbutt or anything like that. Therefore, it can't be defamation, which in my opinion is just not how the case law is written. All right, next argument. The trial court should have dismissed Depp's claims because the doctrine of issue preclusion prevents relitigation of the UK court's ruling that Heard's abuse accusations are substantially true. This is potentially the number one section that goes into bucket 4. Absolutely no chance this wins. Never would a case take a UK judgment against a different defendant and apply it to a separate defendant here in the United States. Their rules of law are completely different. The way that that case was decided seems absolutely wild and against the evidence in the case. It still stands in the UK because that's how they do things over there, but it would never be applied here. Even sometimes state to state, where our judicial systems are very similar, we don't apply this. It's not res judicata all the time because of minor differences state to state. So there is no way that this would have been res judicata. And in case you don't know, let me just give you a synopsis of what happened. In the UK, we talked about how Johnny Depp sued the Sun Times. Went to trial where the judge was the finder of fact and the finder of law. The judge basically let Amber Heard say whatever, didn't provide a lot of corroborating evidence, did look at some of the medical statements that Amber Heard made to some therapists. Johnny Depp testified. He didn't believe Johnny Depp. He did believe Amber Heard. He ruled in favor of Amber Heard and found her to be substantially or mostly credible, and that multiple items of abuse took place at the hands of Johnny Depp. All that being said, never would a court here throw out a case against somebody else because you lost, even if it's a similar case against a different defendant. So we're going to skip through here. Although, is this where she also talks about, let's read through it. To establish issue preclusion, a party must show that the relevant factual issue was litigated in the prior proceeding. It wasn't. That it was essential to the prior judgment. It wasn't. And that it resulted in a valid final judgment against the party to whom the doctrine is sought to be applied. That's true. It was found against Johnny Depp, which is who they were trying to find against here. So one section or one element is true. In certain circumstances, they must show mutuality between the two proceedings. They have recognized neutrality doctrine should not be mechanistically applied when it is compellingly clear from the prior record that the party in the subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated and lost an issue of fact which was essential to the prior judgment. No way. No way. Yeah, whether an issue is precluded should be a question of law. I want to get into when they talked about who it seemed like won the UK trial. I want to get to that. So let me just skim through here. The UK trial did reject Depp's claims. There's no question Depp had full and fair opportunity to litigate this issue. Incorrect. Because Amber Heard, he was not afforded the same rights because Amber Heard was not a party. It was not the same discovery because Amber Heard is not a party. We've been over this. We don't need to do it again. Depp had his day in court in UK against the Sun. I agree. He had his day in court against the Sun, not against Amber Heard. All right, here we go. The trial court erred in denying Heard's motion to set aside the jury verdict based on Depp's failure to prove actual malice. Okay, so actual malice is a big deal throughout this. It's an element you have to prove. There's a jury instruction we're going to talk about later. But here's one of the things they've hung their hat on. Both under the First Amendment as a matter of Virginia state law, Depp as a public figure challenging statements on the public to the public on the matter of public concern was required to prove by clear and convincing evidence that each statement was made with actual malice. Actual malice is a term of art. That means that the defendant either knew her statement was false at the time she published it or published it with reckless disregard to its truth, and that she subjectively entertained serious doubt regarding the truth but published it anyway. In defamation by implication cases such as this one, establishing actual malice requires making a second showing. Not only was Depp required to show knowledge of or recklessness in regard to the falsity of the statement's defamatory meaning, he also was required to demonstrate that either the defendant intended to communicate the defamatory meaning or knew of the defamatory meaning and was reckless in regard to it. This falls into the category of, right? And that's why I said them in the beginning, so we can kind of put these in the boxes where they belong. This falls into the category of, you don't think that he proved actual malice, but a jury read the definitions, listened to the evidence, and literally wrote down that they feel like these were committed with actual malice. And so if a jury misunderstands something, sometimes that really sucks. But that's not a reason to appeal here unless it is obvious and it is a misstatement of the law and a miscarriage of justice. But in this situation, if they felt like she was reckless, or she did know that it was defamatory, or she did know or should have known that it was false, if the jury felt that way and made that decision, it's over. You've made this argument to a jury already. Now, we'll get to the jury instruction. That's a little different because the jury didn't hear that instruction. But to me, this is purely something that's already been decided by the jury, and they're rehashing the argument like I've told you before. This happens all the time in appeals, but it's like you had the opportunity to make this argument to the jury and they didn't buy it. Without this requirement, a defendant could be held liable for what was not intended to be said, which would eviscerate the First Amendment protections recognized by the U.S. Supreme Court. Again, if the jury believed that Amber Heard did not mean to hurt Johnny Depp and actually wanted to keep this out of Johnny Depp all the time, why did she have to say what year this all happened? Why couldn't she have said, I was the victim of domestic violence in the past, and now I'm standing up against it? Even if she would have said, I had to feel the wrath against, or going against powerful men in Hollywood, because she's dated lots of powerful men in Hollywood. So why couldn't she just make it more vague? Why did she have to put the timing element to it? I think we all know, and I think the jury knew. That's the point. I really think the jury knew, and I think it was hammered home when she started adding these details to make Johnny look even worse and really make it look like more of a mountain than it was. Simply because a statement can reasonably be read to contain a defamatory inference does not mean that the publisher of the statement either intended the statement to contain such a defamatory implication or even knew that the readers could reasonably interpret the statements to contain the defamatory implication. Whether the trial record is sufficient to support a finding of actual malice is a question of law, and this court must make an independent review of the record. The judge must independently decide whether the evidence is sufficient to cross the constitutional threshold that bars the entry of any judgment that is not supported by clear and convincing proof of actual malice. So the judge has to determine, could this ever get there? Not a very high bar, but then it's up to the jury to decide if it actually did get there. Significantly, in deciding this issue, the court must evaluate the record in light of Depp's burden to prove two prongs of actual malice by clear and convincing evidence. He failed to meet that burden, and therefore the court should reverse and enter judgment for Heard. They say this a couple of times throughout. It's like, we don't just want a new trial. We want to win. Right here. Forget this jury system. These people don't know what they're talking about. You make the decision, judge, and make it for us. That's not going to happen. There's a 0% chance that they flip this and give Amber Heard the win. Best case scenario is a new trial for her. All right. They failed by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implications. Again, to me, this falls in the bucket of you tried to argue and probably could have stuck to this argument and made a better argument to the jury that here's what she intended. She intended to tell her opinion, her side, her feelings. That these instances and these words and text messages made her feel like she was abused, and therefore that's why she wrote this op-ed and stood up against it. But when you start to literally explain stories that the jury believed were not true and were just lies, that's where actual malice comes in. That's where the defamatory implications come in. If you're willing to do it right now on the stand, they're allowed to use that context and say, then she probably did it in how she wrote this letter, because when I read this op-ed, I feel like it's the same thing she was trying to do on the stand. Convince people Johnny Depp is bad and is a monster, and she wants to hurt him. That's a reasonable step that the jury took in this case, I think, which is why when you write things like this in appeal, I don't think this is a very strong argument, because I think the jury already decided against you. And appellate courts really don't want to disregard juror opinions. Now, it's going to be couched in, this is a judicial opinion, this is a question of law, because the court can't make the decisions, the fact decisions. So they have to couch it in a question of law, but I think it's more of a question of fact. The evidence at trial fell far short of establishing by clear and convincing evidence that she had the communicative intent to accuse Johnny Depp of domestic violence. I just totally disagree. And I think the jury did too. By the way, I will get to this later. The undisputed evidence showed that the ACLU proposed that Heard author an op-ed, The Ways in Which Survivors of Gender-Based Violence Have Been Made Less Safe Under the Former Presidential Administration. The ACLU then prepared the initial draft of the op-ed. Heard engaged her attorneys and based on their advice made significant efforts to remove all references to Depp. So we know Depp was in there. It says she wrote it. Based on their advice, as Heard explained, the purpose of the op-ed was not to discuss Johnny Depp or the particular allegations raised in 2016, but rather to discuss what happened to her in the public arena after she spoke out. But again, we know nobody's going to read it without Johnny Depp references. In sum, Depp presented no evidence, much less clear and convincing evidence that Heard either intended to communicate through the op-ed that Depp abused her or knew the defamatory meaning that was reckless in regard to it. Yet she hired specialists, lawyers that handled defamation cases and defamation situations. To me, there was a lot there. A lot there. All right. He failed to prove that Heard either knew that the alleged implication that he had abused her was false or subjectively entertained serious doubts about its truth. And again, it is not a far stretch for me to believe that the jury looked at the other stories, applied it to this op-ed, and said, this is what she was thinking about, and none of this is true. She implied all of this in the op-ed, and it's not true, and that's how they got there. The appellate court does not want to get into the minds of the jury and try to figure out if they knew this or thought that on fact questions. So all of these have to be questions of law, and I think that's where they're missing them, and this is kind of why they fall in that category to me. Significant difference between proof of actual malice and mere proof of falsity. Depp cannot prevail merely by proving that the abuse did not occur. This is where some people are saying, oh, they're admitting it didn't occur. They're admitting that she lied. They're not saying that. They're basically saying, you know, even if you believe the worst, which lawyers make this argument all the time, even if you believe the worst, we still win, right? So even if you believe nothing she said was true, we still win. And there are some legal arguments that come down on that side, right? Just like the defense in a criminal defense case, right? If we sit there and we play tic-tac-toe and we do nothing, we don't ask a single person a question, the defendant doesn't testify, the lawyers don't say anything, and they don't prove their case, we still win. Doesn't seem fair, doesn't seem right, and no lawyer actually does that, hopefully. But there are situations where you can say, even if the worst thing happens, we should still win as a matter of law. And that's what they argue here. Depp alleged that the op-ed falsely implied that Heard was a victim of domestic abuse by him because actual malice is a subjective standard. Agreed. Whether Heard believed Depp abused her must be judged by her own state of mind. I agree. And I think that the lawyers at trial did not do a good job of simplifying it, that this was her belief based on X, Y, and Z. Instead, they tried to prove that the monster Johnny Depp did these nasty, horrible things to Amber Heard, and the jury did not believe that. I think there is a world in which they could have proved to the jury that in her mind and in her opinion, based on 2 or 3 events, she thinks that there was some domestic violence and she was a victim. Even if at other times Johnny Depp was a victim. She could have even admitted that and still won this case. But it's because of the stories she told that the jury did not believe that she lost this case. Heard testified unequivocally that she believed Depp had abused her physically, verbally, emotionally, and psychologically. Depp and his expert witness conceded that the abuse can take place in many forms. We've already talked about this. Depp demanded that Heard cut him with a knife. He engaged in violent behavior in Heard's vicinity on multiple occasions, kicking cabinets. He exhibited jealous and controlling behavior. He admitted to headbutting her, though he claimed it was unintentional, which I agree with. I remember that. That's why I keep referencing that. He also admitted to grabbing her arm, I believe, or her wrist at some point to move her out of the way because she was being crazy, is what he said. But she could say, when he physically grabbed me like that, it really hurt, and I felt like that was abuse. Depp told Heard on one occasion, I left last night because I just couldn't take any more physicality, more physical abuse on each other. Okay? So, all of these statements, do you see the bottle incident in here? Do you see her broken nose? Do you see her cut feet? Do you see her cut arms? Do you see her bruised face? Even the appellate lawyers know that those are not good arguments that Amber Heard made, that nobody believes those arguments, that the jury did not believe them, and that is why she lost. If instead Amber Heard would have taken the stand, would have said these 1, 2, 3, 4 5 points, and Johnny told the truth, right? I mean, at least the jury believed Johnny told the truth. So he admitted to some of this. He said it was unintentional, but even he admitted that he said bad things, right? That it was physical, that the relationship was bad. So this argument that they are making may have worked if they were talking about a completely different trial than the trial that we watched. Even if the jury could have properly concluded that these undisputed facts did not constitute abuse, Depp presented no evidence that undercut her testimony that she believed this conduct amounted to abuse. Consequently, Depp failed to meet his burden on the second prong. Here is why this misses. Because at trial, in order to prove abuse, she went so far above and beyond this and told 100 other stories that Johnny Depp just said were flat out not true, that other witnesses said were not true, that law enforcement officers said were not true, that some biased witnesses said were not true, some unbiased witnesses said were not true, some medical professionals said they had no evidence of it. That's the problem here. That's what's just not mentioned anywhere in this appeal. All right, trial court erred in failing to grant a new trial for multiple reasons. What's the first one? A bunch of evidentiary issues. Every single case, especially one that lasts for weeks, is going to have a ton of evidentiary issues or rulings you disagree with. As this trial was going, if you watch back my recaps or when I was watching any of the days while the trial was live streaming, whether I was on somebody else's channel or whatever, I disagreed with a lot of Judge A's rulings, a lot of her hearsay rulings, some of her relevance rulings, how she handled booting the witness in the middle of trial. I disagreed with a lot of that. If I was a judge, I probably would have done it differently. Was it unfair in one side? No. She was making the rulings she thought was correct. I don't think she abused her discretion. Legally, did she get some wrong? Probably. I would say absolutely she got some wrong. Did they come to the level that they severely prejudiced one side or the other? I don't think so. There were parts here and there. And if anything, if I remember back during the trial, I actually think they hurt Johnny more than they hurt Amber. Some of her rulings, especially on hearsay. But watching this trial just as a trial lawyer myself, a civil trial lawyer, I didn't think they rose to that level, even though I did disagree with some of the rulings that she made. The trial court's numerous erroneous evidentiary rulings prevented the jury from receiving evidence of highly probative truth of the implication Depp alleged the op-ed conveyed, Heard's lack of actual malice, while permitting the jury to receive irrelevant and unduly prejudicial evidence used by Depp to attack Heard on a purely collateral matters. Each of these evidentiary errors standing alone would warrant a new trial. That's just too much, right? That's just biting off more than you can chew to say any one of these is enough for a new trial, but we have tons of them. It's almost better when you make the argument that any one of them, maybe not, but altogether, this was just too prejudicial, and in the interest of justice, we need a new trial. Explaining that two or more individually harmless errors have potential to prejudice the defendant to the same extent as single reversible error if multiple errors so fatally infect this trial as to violate fundamental fairness. That's what the case law says. So it has to be fundamentally unfair. It needs to be so bad that this was just fundamentally unfair. All right. Trial court erred by excluding evidence of Depp's abuse and Heard's state of mind. Okay. The reports of abuse to medical providers plainly were admissible. I have talked to board certified civil trial lawyers that think that these records should have been admitted. I understand why they were not. I think they were purely hearsay. I think they were self-serving hearsay, admissions made by herself just to try to prove a point. So I understand why they didn't come in. I also thought they were more prejudicial than probative. I don't think they proved anything. And I think that she was able to sit on that stand and say every single thing that she said in those medical records. I also did not see, because I didn't see the medical records, if they actually were statements that were made in the course of her treatment and to aid in medical treatment. Did they say after this session, okay, we're going to prescribe this drug to you? Did they say work on this meditation, or here's some therapy or something that you can try to do? Or was it just a time where they sat there and she spoke? Because there is a difference there. This one would fall into the bucket, though, of it depends on Virginia law. Virginia law may be a little bit different than here in Florida, but I think there are arguments on both sides of this. I feel like it's inadmissible hearsay. I think the judge made the right decision, but maybe the appellate court will disagree. So we know about the mountains of evidence she talked about, right? She treated with several medical professionals as a result of the volatile and violent relationship. A number of those documented her contemporaneous statements about Depp's abuse in medical records. Now, were they really contemporaneous? Depends on your definition. The trial court, however, excluded this evidence as hearsay, which Depp then used as both a shield and a sword, which he absolutely did. That is true. Not only did Depp convince the court to preclude her from presenting relevant admissible evidence to corroborate her claims, but Depp then weaponized that exclusion, arguing to the jury that such evidence did not exist. Ms. Heard has told you she has mountains of evidence of abuse, but there are no medical records reflecting that she had sustained any injuries from the abuse she claimed. Okay, so I'm highlighting this part because it was actually very ethical of these lawyers to put this in, because they could have just said, but there are no medical records, and put a period there and put this cite. And this actually looks like a better argument. But the fact that they did the right thing and completed the argument, which I'm sure Johnny Depp's team would have done, which would have made these lawyers look even worse, which is how shady lawyers should look if they try something like this. But they said that she sustained any injuries from the abuse she claims. It was clear to me, and by the questions that they asked Amber Heard, they didn't say, you never saw a mental health counselor while she was on the stand and cross, did they? No. They said, did you ever go to the ER? Did you ever go to the urgent care? Anybody ever fix a broken nose? Anybody ever stitch up a cut you had? Never, because you didn't go to the doctor for any of these injuries. Or the bottle incident. Did you get checked out? Was there a rape kit? Those were the medical records they were referencing when they were talking about nothing showing she sustained any of the injuries she testified to. No corroborating documents. The only thing you had were you were talking to some mental health professionals. They also said that there were mountains of medical records that were out, and they did use it as a sword and shield. Here is one thing I want to pause real quick. I don't think I'm going to get it done in an hour, but we're going to be pretty close. Not a ton of overtime today. A trial lawyer's dilemma comes when you fight a ruling from the court and you think the court made the wrong call. You have to make the decision. And at this point, you have to make the decision. Do you want to just ignore that now and make it a good appellate issue? Or do you want to try to tiptoe and reference that argument that you think is very helpful for you and is going to make it a much better trial and much better chance of success at trial, but it may hurt your appeal? And every trial lawyer I've ever talked to and every trial I've ever watched or been a part of, they push to make it the best trial and get as close to that argument as they possibly can without violating a court order. They try to get the better crack at a trial because you have a way better statistical chance at winning a civil trial than winning an appeal. So, what did Amber Heard's team do here? She referenced multiple times on the stand that she talked to people about this, that she did tell someone about this. I think she even referenced her therapist. I think her expert referenced that she treated with these therapists. She said everything that's in these medical records, she said to the jury in a very similar way. So they did everything they could at trial to make sure the jury knew that she treated with a therapist for these issues without actually saying she did or entering these notes. Number two, this happened a ton later in the appeal. We get to the UK decision. Both sides tried to argue that the outcome of the UK trial was good for them without actually saying they won. And that's what trial lawyers do, right? You're not going to give the decision, but if we reference it, we want it to be a positive reference. I even mentioned that when we were breaking down and reacting to the trial. Now, here's the issue. Because you made the trial better and tried to make this judicial ruling less prejudicial, it hurts your chances at appeal for this issue. Because the appellate court can look down and say, I actually think that these records should have come in. I think the judge was wrong. I don't think they're inadmissible hearsay, or I think they're an exception to hearsay. However, Did they prejudice the trial enough to make it a reversible error? And if they look through the transcript and they say, well, listen, she referenced that she saw her therapist here. Everything and all the stories in her therapy notes, she was able to testify to that on the stand. So the jury heard that. Her expert referenced that, she had gone to therapy for this or met with a therapist for that. So all of the information actually did go before the jury because her lawyers were able to do it in a way that was admissible, even though they weren't able to get into these documents that we actually think they should have gotten into. So even though that they were incorrectly kept out, they were actually able to make all these arguments. So therefore, it's not reversible error. That's the problem sometimes with being a good trial lawyer, making your best chance at trial. Sometimes it can actually hurt your appellate chances. All right. All right, let's read it a little bit. Virginia's hearsay rule precludes the introduction of an out-of-court statement offered to prove truth matter certain only if the statements do not fall within one of the exceptions. We know that. One exception is medical diagnosis or treatment. So that's because I didn't see it. I don't even know if there was a diagnosis or treatment with this. Medical and psychological records that included victims' statements were properly admitted under this hearsay exception. The trial court should have admitted Heard's statements to medical providers under this exception. Separately, they should have admitted the statements about the abuse as non-hearsay assertions offered to prove Heard's state of mind. It is black letter law that this should come in. A statement that is offered to prove state of mind is not hearsay because it's not offered for the truth. Come on, they weren't gonna. That's one of those where it's like lawyers got a lawyer, right? That needs to be a lawyer. I need to make a lawyer short on that. It's like say something that you want somebody else to believe, but that you're not offering it for the truth, because that's literally what it is. She's going to talk about all of her abuse, but I'm not offering it for the truth. Because of his burden to prove actual malice, Heard's subjective state of mind regarding whether the abuse occurred was a primary issue in the case. And it should have been, but I don't think it was developed well enough by her lawyers at trial. And then we know she did go to these therapists. She was treated. She did make statements to them. Although there were some inconsistencies in them, we don't need to get into that. All right. The trial court wrongly excluded corroborating testimony of Heard's allegations. And now we're going to get into Stephen Deuters and some other people that she says corroborate what she had. And this is something that kind of goes hand in hand with forum non-convenience. Why didn't she call these people to the stand? Why didn't she let them testify? Because maybe I think Stephen Deuters specifically would not have been a good witness for her. Deuters corroborated Heard's allegations of abuse from the flight. A statement by a party's agent or employee made during the term of the agency or employment concerning the matter within the scope of such agency or employment is an exception. That is true, the agency exception. And he said, when I told Depp he kicked you, he cried. It's not really an admission, but okay. He sent Heard this message after Depp told Deuters to smooth whatever issue existed with Heard by texting Heard and telling her whatever she needs to hear. Again, I think that can kind of cut both ways. I'm not sure what that proves specifically. I mean, I think it's bad for Johnny, but I don't know. The trial court should have admitted this evidence as a party opponent admission because Deuters was an agent of Depp, and Depp specifically instructed Deuters to communicate with Heard regarding the altercation. I don't think so. But I think they could have called him and asked him. The trial court improperly excluded the UK judgment. Okay, so here is another one that I think there's just no way. There's no way that this other judgment, that just because he lost against the Sun-Times means he should lose against Amber Heard. It would have been horribly prejudicial, and it's a different case with different standards and different fact finders. So we don't really need to get into this today because I totally disagree with this entire section of the appeal. Trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. So this is actually an interesting question of law that would fall into the bucket of what is Virginia going to say? Are they going to agree with the trial court? Are they going to agree with Johnny's lawyers? Are they going to agree with Amber's lawyers? Depp alleged that Heard defamed him by falsely writing, I became a public figure representing domestic abuse. On cross-examination, they wanted to ask him, is this true? I think that was a great question. I think that's a great argument, personally. Okay, sorry. But they objected to legal conclusion, which was a good objection because this is what the case is about. I think they should have let him answer it. I actually agree with Amber's team here that they should have let him answer, is this actually true? because they weren't arguing that the words she said were literally false, but that everything they were implying and trying to mean was false. And the reason she said them and the way she said them and the content of them is actually not true. So I think that's interesting. I actually think he should have been able to answer it. And I think Johnny's team could have still won, even if he answered the question that they were technically true. Or he could have answered it as, she thought she was, but she was not a domestic abuse victim or something like that. He could have qualified his answer like that. And I think that probably would have been the best way to handle it. Do I think it rises to the level of, oh no. Do I think it rises to the level of reversible error? No. All right. Trial court erroneously admitted irrelevant and prejudicial evidence. In at least 2 instances, the trial court admitted irrelevant and unduly prejudicial evidence that had nothing to do with this case, but allowed Depp to attack Heard's character. This evidence is the donation versus the pledge. It has to be relevant. We know that. Where is it? Here we go. Trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate money to charity. The trial court committed reversible error when it admitted collateral source, basically saying that she pledged to donate the money, but she didn't actually donate it. It made her look like a bad person. But if you remember, Amber Heard opened the door to this. Her character is at issue. Whether or not she tells the truth or lies is at issue. This is going to be one of those that falls into the bucket of, unless we totally misunderstand Virginia law, and if it actually is a situation where they can never get into a collateral source to talk about whether she's true or impeach her with this, then maybe they win on this point. I really don't think so, based on everything that I've read and all the case law that I've read and the appeals coming from both sides. The domestic abuse, again, they didn't get into the fact that she was arrested. They got into the fact and impeached her only after she opened the door multiple times that she has been accused of something like this before. And people have seen her get violent with something like this before. All right, hold on a second. I got to figure out how to see both this and the chat. All right. All right. During cross-examination, Depp asked Heard about domestic abuse he alleged she engaged in during prior relationship. She denied the allegation. That should have been the end of it. So she should have just been able to lie. That doesn't make any sense. You're allowed to impeach somebody if they do, in fact, lie. However, the court permitted Depp to call Leonard, a former officer, to testify that in 2009, she saw Heard acting aggressively toward her then partner, grabbing her partner and pulling her partner's necklace from her neck, which is similar to some allegations that Amber Heard had against Johnny Depp. So why is that not fair game? The court's decision to admit Leonard's testimony regarding an incident occurred 9 years before the publication served no legitimate purpose. All right. Let's see what we got here. The evidentiary rulings encourage the jury to award damages unrelated to the op-ed. So this section here, if they win, it will be something I don't understand. I don't think that any of the lawyers made a cogent and clear argument about splitting up and cutting and what damages would potentially be appropriate in this case. So when they make these arguments about these damages shouldn't have counted, but these should have, nobody, in my opinion, explained that appropriately enough to the jury to where I think the jury picked a winner, wanted to hammer Amber Heard. They did that with the punitive damages, $5 million, and they picked the number 10 million kind of out of thin air based on less than what the plaintiff's lawyers asked for. That's my opinion, because I don't think this was explained perfectly by either side. All right. The trial court's erroneous evidentiary rulings also left the jury without crucial evidence regarding Depp's reputation and therefore prevented the jury from accurately assessing any harm proximately caused by the op-ed. First, the trial court erroneously excluded as hearsay articles relevant to Depp's reputation prior to the publication. We heard so many titles of articles. We heard experts about what his reputation was like. How can they say the jury did not get enough evidence about his reputation and when his reputation went up and down based on scores? We got tons of evidence on that, more than I wanted, frankly. We knew that he had issues with his reputation prior to this, but it was not the same as this result. Okay, second, the trial court excluded relevant evidence related to the UK proceeding, including the Sun article and the UK judgment. At a minimum, the jury should have been permitted to determine whether it was appropriate to apportion any claimed reputational damages between the op-ed and the Sun article, upholding admission of prior and contemporaneous articles to mitigate damages because the defendant could not be held liable for injuries that it did not cause. Meaning the Sun-Times article hurt him more or just as much as this case. And I think there was some, again, this is something I was confused about throughout the whole trial. There was something about not giving damages up to a certain date because of the Sun article, but it was just very confusing to me, if I'm being honest. And maybe I missed that. Trial court agreed this evidence was relevant, but it nevertheless precluded her from introducing the Sun article, the UK judgment, and published media reports. But it did let them say that there was only a certain date range that they could award damages for. It was a little confusing, and maybe it was because of certain evidentiary rulings that it made it confusing. And if that's the case, they may have a legitimate argument, but they still didn't give him the full value of the damages they asked for. That's their problem. If they would have given him every penny the plaintiffs asked for, then maybe you have a better argument here, as well as a little bit later, which we'll get to. Similarly, by precluding her from admitting the UK judgment, the jury was left with a false impression about Depp's reputation. I disagree with that. Because of the UK proceeding and the significant corresponding media attention, by November 2nd of 2020, the world already saw him as a domestic abuser. Nonetheless, the trial court kept that critical information from the jury. So, I do think that the way the UK judgment was discussed was much better for Johnny Depp than it could have gone. And if the appellate court thinks that the judgment should have been relevant evidence to show his reputation, and I think there may have been a way to do it without saying that the UK court believed Amber Heard and found her to be credible. I think there's a way they could have said there was a ruling in the UK that, but it didn't. I mean, I guess it did call him an abuser. It's really hard, and you don't want, it's just so prejudicial that I think that's why we have the argument of weighing something that is probative versus how prejudicial it is, because that would be the ultimate piece of prejudicial evidence. And that's probably why the court kept it out. And again, abuse of discretion. Abuse of discretion is the standard. Did the judge abuse her discretion, or did she determine and make a determination? And we have to give power to these trial court judges. Did she abuse her discretion in not allowing it in? I don't think she did. The jury was allowed to hear testimony of Depp's harm as far back as 2016, but they weren't able to fully assess the reputational harm unrelated to the op-ed. Well, it's hard. I mean, anybody's reputational harm is hard, but you have to explain that. You had to fight that, and Johnny had to prove it. Johnny had to prove that it was this that hurt him, and he did that by using experts and testimony of his agent and other people. That's how that works. And it turns out that the jury didn't believe it. While the jury was allowed to hear testimony of him as far back as 2016, they were not able to fully assess this. As discussed more fully below, the impact of this error was compounded by the separate error in permitting Depp to claim damages based on conduct unrelated to the op-ed, including the 2016 restraining order, Well, they made him prove the timeline because they said she wasn't even talking about him. Or how did this imply Johnny Depp? So they had to get into that. All of this resulted in an indefensible $10 million compensatory damage verdict and $5 million punitive damages verdict, a verdict that demands reversal. All right, we're going to get there because I have some comments on that. The trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because the evidence established that Heard did not publish it. This is one that falls in the bucket of what is the law in Virginia? Because she says that she published it. Her reposting of it on Twitter, which I guess is not publication on its own. Some states at least say it's not. What's Virginia going to say? What's Virginia going to adopt? Did she publish it? To me, she wrote the article. She published it on her Twitter. She promoted it. She became an ambassador off of it. But this is one I just don't know the answer to. How's the appellate court going to come down? If I had to guess, and again, when lawyers guess, we aren't geniuses. It's just usually the appellate court is going to agree with the trial court's error unless they made a huge mistake. Huge. Right? So the reason I'm guessing they're just going to agree with what the lower court did is because the lower court already did this analysis. They reviewed the case law and they felt confident with their decision. And so the appellate court usually is going to err on the side of agreeing with the lower court. Obviously not always. All right. The court improperly instructed the jury on actual malice. This is interesting, right? Because the trial court refused Heard's proposed jury instruction, which set forth the communicative intent prong of actual malice that Depp was required to prove by clear and convincing evidence for his defamation by implication. As a result, the instructions given to the jury on actual malice were missing the crucial component of the standard, and a new trial on liability, therefore, is required. The trial court gave 2 jury instructions defining actual malice. Instruction AA addressed only the falsity prong of actual malice. Instruction BB correctly clarified that actual malice is not established by ill will or hatred, even though Amber Heard's lawyers argued that. Heard's proposed jury instruction CC, which the trial court refused, addressed the communicative intent prong of actual malice that must be established when, as here, the claim is for defamation by implication. That is, the jury should have been instructed that it also must find by clear and convincing evidence that Amber Heard intended to communicate the defamatory implication or knew of the defamatory implication and was reckless in regard to it. Do we think that if that, my favorite is when lawyers argue about a few words in jury instructions, because when you have such an overwhelmingly favorable verdict in the eyes of Johnny Depp and on the side of Johnny Depp, do we really think that adding a line like this, like communicative intent, they must find by clear and convincing evidence that Ms. Heard either intended to communicate the defamatory implication or knew of the defamatory implication and was reckless in regard to it, that if they would have added that line, that really would have changed this jury's verdict? There's no way. They gave 2 definitions. They talked about this. Adding this into the jury instructions would have made literally no difference. And this was arguments that Amber Heard's lawyers made to this jury. When considering whether a jury instruction was properly refused, the evidence is viewed in the light most favorable to the proponent of the instruction. As explained above, Depp presented no evidence that she either intended to communicate through the op-ed that he engaged in domestic abuse seriously, or knew of the defamatory meaning and was reckless in regard to it. Maybe this would have been a better argument again if she did not go overboard with the stories and things that she says Johnny did, how he did them, why he did them. The jury verdicts are inherently and irreconcilably inconsistent, meaning you can't say Amber Heard is an abuser and then say Amber Heard is not an abuser. That's what she argues here. To say that she is liable for defamation, all 3 counts, and that she lied about being a domestic abuse victim, but then, sorry, I said that backwards. They can't say that she lied about being a domestic abuse victim and then also didn't lie about being a domestic abuse victim. Because in the 3 counts that Johnny won, They're basically saying Amber lied, actual malice, defamation, not in a victim. But then on the count that she won with the Waldman statement, Amber didn't lie. And on its face, that may make sense. I can even make that argument in my head. However, courts hate to say that jury verdicts are inconsistent, and it is very easy to see the argument here how these verdicts are not inconsistent because of the Adam Waldman statements and the factual scenarios contained in that statement. They could very easily believe that she lied about a bunch of this stuff, did it with actual malice to hurt Johnny Depp, but that her and her friends, more importantly, did not break a few bottles, rough the place up, call the cops multiple times to try to set something up. And they might not think that because she didn't even cooperate with the cops and tell them anything. And if she was going to try to set him up with that, why wouldn't she file a police report there and tell the cops that he abused her? So it is plausible how they got to ruling in favor of Amber Heard on one of her counts. And again, we have been over this so many times. Depp argued prior to trial, this case involves two essentially mirror image defamation claims asserted against the only two people who truly know whether the statements at issue are true or false. If Ms. Depp did not abuse Ms. Heard, she independently knows her claims that he did is false. If Mr. Depp did abuse Ms. Heard during their brief marriage, he knows that Mr. Waldman's statements calling Ms. Heard a liar are false. This is an oversimplification, the way Johnny's lawyers explained it. This is a great point on how lawyers can use words, and they tell those words to juries. But juries are not stupid. They can read words and understand words. And although this is what Johnny's lawyers said to them, and I don't think they were being disingenuous, I think they actually believe this, and I actually can see the case this way as well. But instead, the jury read the specific words, and they felt like Amber Heard acted with actual malice and did defame Johnny Depp, but they also believed that Adam Waldman's words were false. I don't know if I agree with them, right? Based on the law enforcement, the police reports, and whatever, I think they were an opinion by Adam Waldman, but this jury believed that they were false and defamatory. And I think there's absolutely a plausible way, absolutely enough of a way for the appellate court to say no way on this one. This is a zero-win argument for me. All right, here's my favorite argument that defendants make. The jury's damages award is excessive. The Virginia court has instructed the courts have a duty to correct a verdict that plainly appears to be unfair or would result in a miscarriage of justice. This happens in every one of our trials that we win. This is an argument that the defense makes. The award is too much. Whether it's $500,000 or $10 million, the award is always too much. It is a miscarriage of justice. They try to do it in jury selection. Tell potential jurors, the reason your life is so expensive is because these big verdicts, we hate these big verdicts. You guys and the jury should make sure we don't get these big verdicts. The appellate court should make sure we don't get these big verdicts. Well, then maybe stop having clients that commit horrible acts that cost people tons of money and cause people inordinate amounts of pain. That the only just result is a huge verdict. Okay, setting aside a jury verdict is necessary when the award is so excessive that it shocks the conscience, creating the impression that the jury was influenced by passion, corruption, or prejudice. So what do we think they were? Which one of these do we think the jury was influenced by? Passion, corruption, or prejudice? The jury has misconceived or misunderstood the facts or the law. Or the award was so out of proportion with the injury suffered as to suggest that it is not the product of a fair and impartial decision. If the size of the verdict bears no reasonable relation to the damages disclosed by the evidence, it is manifestly unfair. A trial court's denial of a motion to set aside the verdict as excessive is a subject review for abuse of discretion. So they've already asked trial court said no. So here's what I'm going to say why this fails miserably. They gave him $10 million, right? $15 million. It's already been reduced to 10.35. Johnny Depp's lawyers were asking for 30 or 50 million or whatever. Amber Heard's lawyers were asking for 50 million. Amber Heard's lawyers literally asked for more money than the jury awarded Johnny Depp. So in my reply brief, if I was Johnny Depp's lawyers, I would say, Judge, if this is so manifestly unfair and unjust as a verdict, and Amber Heard's lawyers are saying that they know that to be true, we disagree, obviously, but they're saying they know that to be true, yet Amber Heard herself and her lawyers asked for $50 million or whatever it was, $100 million in their lawsuit under the same statute and facts, and actually with less cognizable damages because she makes less per movie. So let's just say they both lost some movies. Johnny Depp's claims are going to be more valuable. So that blows this argument out of the water. The court will not even consider this, in my opinion. Like that's low to have a counterclaim asking for 10 times this amount of money and then saying it's just totally unfair. The jury shouldn't even be able to consider this amount. Depp's damages are limited to the narrow period between the publication of the op-ed. In the instance of the UK judgment, here it is, right? Which I think they did a horrible job of explaining and closing. And if they would have done a better job, maybe the damages would have been limited. But all it took was for him to lose Pirates of the Caribbean. If they thought he lost Pirates, it's worth more than $10 million, right? Like we know he was going to get paid more than $10 million for Pirates. December 18th to November 2nd, December 18th, 2018 to November 2nd, 2020, Depp represented he would not seek damages after November 2nd of 2020, which was the UK judgment. So it was just these 2 years. He failed to prove any pecuniary damages resulting from the op-ed in that time. And he did not seek emotional distress damages, leaving reputational harm as the only possible source of damages. The jury's verdict of $10 million in compensatory damages is grossly disproportionate to any reputational harm the op-ed could have caused during that small window. Weren't they showing he was making like $45 million a year or something? I mean, to me, with this kind of money that he was making, $10 million is nowhere near excessive. And usually these awards only get set aside or really reduced if like they ask for 50 million and the jury comes back with 500 million. Then sometimes we can be like, maybe reduce it a little bit or whatever, but not in this situation. There's no evidence the jury could rely on to determine Depp suffered any pecuniary loss because of the op-ed. Principally claimed that he lost a role in Pirates 6 because of the op-ed. The trial record shows that doesn't. Okay, so here's the point, okay? Here's where they lose every time. And if you're an appellate lawyer, which I don't hold myself out, we've done some appeals, but I'm not an appellate specialist. But if you're an appellate lawyer and you find yourself arguing facts to the appellate court that the jury heard and totally disagreed with, you have already lost. Johnny argued he lost Pirates 6. The trial record does not support that conclusion. Depp failed to establish he actually had the part. He said he had it and then lost it. He did not have a written contract. That's true. But they argued you didn't have to have a written contract to have this done in Hollywood. That's not how they do things. Even before the op-ed, the media reported that Depp would not be in the film. So what? That happens all the time. Someone's out and then someone's in. And his agent testified that he was non-committal about giving Depp the role. Also, Depp said he wouldn't take it for $300 million and 1 million alpacas. We all remember that line. But here's the point. Depp said he lost it. He argued he lost it. His agent said he lost it. You didn't need to have a written contract. I think he even testified like they had a deal even though it wasn't written. These are what we call arguments about material facts that a jury has to decide. A jury heard these facts and decided that Johnny Depp did lose Pirates, or at least the op-ed was, I think it was $30 million. Is that what they said? I'm losing money. I'm losing brain space here. But let's say it was $30 million and the jury was like, well, you know what? His reputation was kind of bad beforehand. Maybe this was a third of the reason that he lost Pirates. So let's only give him a third of Pirates. Let's give him $10 million. That's the only one we really feel like we can connect to this op-ed is a third of Pirates. That's $10 million. But let's hammer Amber $5 million punitive damages. Let's go ahead and throw that in there. They're allowed to do that. The jury is allowed to calculate damages in any reasonable way. So they're allowed to do that. All right. Yeah, Disney's corporate rep testified he's not, that no decision maker within the company ever said they would not cast him. That's fine. And this is all things the jury heard, and they still believe they still believe Johnny at least had some monetary damages. It may not have been pirates. It may have just been general reputation damages that maybe he lost other parts in small movies that he was still making money with. Given the jury could not have awarded Depp damages for any pecuniary losses based on the evidence at trial, he never sought emotional distress. Okay, so we hit that part. All right, and the conclusion is just, for the foregoing reasons, Heard requests that this court reverse the judgment against her and either enter a judgment for her, yeah, right, or dismiss Depp's claims without prejudice, or remand for a new trial, which is really their best chance is remand for a new trial. Okay, almost an hour and a half. I literally, you guys know I love to do questions. I have about 5 minutes for questions before I got to get to a 3:30. So June, thanks for joining as a member here. And let me get to as many of the questions as I possibly can. Francis Williams, if AH is watching this, she may try to hire you. I don't think so. I really don't think so. Peter, how did Scamber get away with late last-minute filings, not handing over any devices? And if the therapy notes were allowed, would the doctors be forced to be witnesses? So no, it seems like they would not be forced to be witnesses. I have no idea how she got around not handing over those devices. But it seems like that was the judge's decision, and the judge didn't force her to. Either that, or the judge said, fine, Depp team, you can continue this trial if you want to. And they decided not to. John O'Rourke, have judges ever overturned a jury's verdict during the appeal process? An example, thanks, my guy. Yes. Yes, they absolutely have, when the interests of justice show that the jury got it wrong. Sometimes we've seen, post-conviction cases where there's like DNA or Innocence Project. A jury convicted that person a lot of times, and they overturn those jury verdicts. So yes. Nicholas, I secretly want a new trial in California. They can use the Virginia discovery and refer to the tampered evidence. The damages might even be higher if she shows up. I don't think so, because of the anti-SLAPP in California. I think there are other things that would really stop this lawsuit and potentially get it thrown out altogether. Rich Cat, if you guys haven't checked out the Be a Lawyer shorts from Peter, check them out. Yes, please do. They are a lot of fun. Lexix, thank you for the super sticker. Angela Parker, can JD appeal the UK trial? He tried to. They didn't let him. There is a petition going around, I believe, that a lot of people posted about, though, that you could try to sign, but it doesn't seem like it's going to get him his appeal. Lila Quinones is a new member. Welcome to the crew. Christy Jenner, I loved the latest Be a Lawyer. Shirt size, please. Sending a shirt. A large, probably either a medium or large, but the safer bet is a large, so it's not too snug, on the guns. You got to be careful about that. Thank you, Cynthia. Rich Cat, I always imagine there are file cabinets in every attorney's office with form, letter, appeal paperwork. Not necessarily. There's definitely filing cabinets. Andrea Taylor, thank you so much for the super sticker. And just so you guys know, we have another Be a Lawyer posting tomorrow, so make sure you check that out. We also had a Daryl Brooks filing his intent to appeal by handwritten letter. So make sure you check that out. It's a short video, like 2 minutes after this one's over, because I'm almost done here. Question. They often say there is undisputed evidence for something, but from what I understand, the jury can just disregard evidence because of lacking credibility, even if nobody disputes the evidence, right? Yes, but there has to actually be evidence of the position you're coming to. A jury can't consider something there's no evidence for, if you understand what I'm saying. Like Johnny Depp had to at least testify, I didn't do this, or Amber did do that. And then she can testify and they can disregard her evidence. But like the pirate stuff, there were people that absolutely said that Johnny lost the pirates part because of this. And as long as there's evidence, record testimony and evidence, they can make that decision. Thank you for the super sticker, Rebecca. Stacy P. Hi, Peter. I'm in Tampa too. Perfect weather we have been having. Thanks for all the time you set aside for these videos. Happy to do it. Colby, life's a journey. If she felt the wrath, it's because people knew it was about JD, which goes against her point that it wasn't obviously about JD. There's so much circumstantial evidence that this was about Johnny Depp, right? I mean, it is almost like, I mean, we said it multiple times. It's like she's saying, no, this is not my hand. No, there's no hand sitting next to me. That's what it felt like sometimes. You know, it was like, what are you trying to argue? I'm not following. Dawn, thanks so much again for covering the Delphi, Indiana case yesterday. By the way, it meant so much to see you giving it coverage. Thank you, Dawn. And if anybody wants to check that out, that's a video that's up on our page as well. You may have to hit the live tab. Somebody gave me that pointer the other day. Laura Ruffley, I was listening to a podcast and they recommended your content. I've been here since JDVAH. It was related to the DB content. I thought that was nice. Oh, tell me who it is. I'd love to know who it is, Laura. I appreciate that. I'd love to tell them thank you. Decibel Chaos. How much of the Virginia case will be reconsidered, as in what portion of it likely to be reconsidered in the appeal? Is it the same judge? Pardon my ignorance. I'm in ballet mode today. I'm not sure what you mean. It goes up to a higher court, an appellate court. They'll put in the whole record evidence. They cite to what page and what line certain portions of the record evidence that they want the judges to read, and the judges will read it and make their decision. It's a higher court, though, not the same judge. Pooh Bear. Peter, do you feel these legit arguments for appeal are ridiculous? It seems to me like throwing stuff against the wall and hoping something sticks. Are you used to hearing ludicrous arguments like this? Yes, literally the damages argument I hear in every single motion for new trial or appeal that we have. And then 3 words that are wrong in a jury instruction that they act like changes the whole case, which in fact it doesn't. But I do think there are some legitimate arguments because I don't know all of the nuances to the case law in Virginia on them. Maybe they're horrible arguments or maybe they're great arguments, but there are quite a few that are absolute zeros, which is why I kind of created those 4 buckets in the beginning that we were going to put arguments in. So hopefully that helped you kind of track with them. Sherry G, thanks for joining here. Crayon Writer, do you read the cited cases? Absolutely not. Do I read all the cited cases in these appellate briefs of these cases? Now, in my cases, I read every cited case. I read every case that we cite, that they cite, that we're going to use, that those cases reference. And I expect these lawyers to do the same. And the reply brief that Johnny's team, I think it's like 20 days, but they can get an extension. It's right around Christmas. That they have to reply. We'll see what kind of case law they come with. I've already seen some of their pretrial motions, and they've already argued these issues and brought this case law. Not a ton new coming in any of these appellate briefs that we've read. Okay, 3:30. I got to check out of here. You all are the best. Loved spending this time with you. Hit that like button. Share with your friends if they want more Amber Heard appellate content. Hopefully we did it a little quicker than you were expecting because we didn't read every word. I'm sure you've seen some channels that have read every word, which is awesome because it's really important to do that. I just kind of highlighted a lot of the arguments. It's one of the longer videos for us, but you all are the best. I appreciate you so much. Check out the Be a Lawyer tomorrow. Let me know what you think of it. Until next time.